Good morning, everyone. My name's Michael. I'm a partner here at the employment team at VWV, and I'm joined by Joe, another partner in the team. We both work with higher education institutions, and as Tamar said, we've also got Jessica Scott-Dye with us, who's our professional support lawyer, who's been very involved in dealing with the question of holiday pay for part-year workers. Jess will respond to questions that go in the Q&A as we go, if she can. Otherwise, she'll take part in the session at the end when Joe and I will try and answer such questions as we can. So moving on to the next slide. Just a quick overview of what we're going to do. So I will talk about setting the scene, giving some background, and then the Supreme Court's judgment in the Brazel case. Joe is then going to look at holiday pay calculations and the impact of the judgment. And then I'm going to look at some strategic considerations at the end. And as I say, after that, hopefully we'll have an opportunity to respond to questions. So going on to the next slide, setting the scene. So the questions we're going to be dealing with in the seminar are how much holiday are workers entitled to? And how much are they entitled to be paid for the holiday? So those are the two elements, how much leave and how much pay for that leave. And this slide sets out some of the background law, the context. So the working time regulations implemented a European directive, not always very successfully, but that's what they did. And under the European directive, there was a requirement for 4 weeks annual leave. The UK enhanced that by a further 1.6 weeks to make the statutory minimum requirement in the UK 5.6 weeks in total. That's set out in Regulation 13 of the Working Time Regulations. Regulation 16 says that holiday is to be paid at the rate of a week's pay for a week's leave. And 16.2 says a week's pay should be calculated in accordance with sections 221 to 224 of the Employment Rights Act. So Regulation 13 deals with the amount of leave and Regulation 16 about the pay. I think that's all pretty understandable, particularly in relation to full-time and traditional part-time workers. So a brief illustration would be that a traditional full-time worker might get, say, £1,000 pay per week. So when they take a holiday for a week, they get paid £1,000 for that holiday. And a traditional part-time worker who works 2.5 days might get £500 a week. And when they take a week's holiday, that's essentially 2.5 days for them, but it's still a week for the purposes of the regulations. They get £500 for that week. So nothing much has changed there. So if we move on to the next slide, the difficulties arise when workers are employed under a permanent contract for the whole year, but only work for part of the year. And the question is, should those workers still get 5.6 weeks holiday, as the full-time workers do who work for the full year, or should they only get holiday for the weeks that they actually work? Prior to the Brazel case that we're going to look at next, both ACAS and the government had advised that employers should prorate the amount of leave that part-year workers receive by applying a multiplier of 12.07%. And you can see on the slide that that's how the 12.07 is worked out, that a full-time worker works 46.4 weeks a year and then has 5.6 weeks holiday, and 5.6 weeks is 12.07% of 46.4 weeks. Some employers applied a sort of prorating system, which eventually came to the same sort of result. So this was seen as a sort of fair way to deal with things, and it avoided the risk of some workers receiving far more holiday for the work they did than others, and as a consequence, far higher uplift in salary for holiday when compared to other workers. So to use an example to illustrate this, if someone worked 12 weeks per year on a permanent contract and receive 5.6 weeks holiday, as it says under the regulations, that would result in a 47% uplift in pay, rather than 12.07% received by a full year worker working 46.4 weeks. So arguably that was seen as rather unfair. So that's why the prorating of entitlement to the amount of leave was, as I say, advised by both ACAS and the government. Moving on to the next slide. Now I'm going to look at the Brazel case itself. So a brief foray into the facts. Mrs. Brazel was a visiting music teacher in a school, and she worked 32 weeks per year, and she had variable hours depending on how many students wanted to learn the instruments that she taught each term. And so the school applied a multiplier to deal with holiday of 12.07%, as advised by ACAS and the government at the time. So at the end of each term, they would tot out how many weeks Mrs. Brazel had worked and then apply the multiplier. And they would then make a payment for holiday at the start of each period of the school holidays while the pupils weren't there. And what Mrs. Brazel said is, hang on, that's all well and good, but I'm entitled to 5.6 weeks holiday under the regulations rather than this prorated amount. Now, the case was litigated all the way through the courts, and the Supreme Court's decision was that all workers on a permanent contract are entitled to 5.6 weeks holiday. There's no mechanism for reducing holiday entitlement on a pro rata basis if someone only works part of the year but works under a permanent contract. And that, the court recognised, would result in something of a windfall for some individuals, but the court felt that that was a relatively minor point, and made the point that there's nothing prohibiting more favourable treatment of these individuals. So the outcome for Mrs. Brazel in particular was that she would get around 17.5% uplift on each hour she worked for holiday, and not the 12.07 that she had been receiving. So looking at the next slide. So it's a quick poll before Joe takes us through how holiday pay is calculated. Have you started to review your university's holiday pay calculations as a result of the Brazel judgment? And that's a yes or a no. I think the poll is open now. It was the usual wait for responses. Okay, so what the poll is telling me is that around 2/3 of the respondents have said yes, they are beginning to review their holiday pay calculations as a result of the judgment, and 1/3 have said no, not yet. And I guess when we get on to the strategic considerations, I think we will be recommending that people do start to review their calculations as a result of the judgment. But that's very useful data to see. And moving on to the next slide, Joe's going to start looking at how holiday pay is calculated.
Thanks, Michael. Morning, everyone. So as Michael said, I'm going to take you through some of the practical implications of the judgment. So looking at the holiday calculations that you would need to put in place. So the starting point, as Michael said, it's that staff who take holiday are entitled to a week's pay in respect of each week of leave they take. And the calculation will depend on the hours that they work and how they're paid. And we look to the Employment Rights Act to determine which calculation fits which category of worker. And once we've determined what a week's pay is, we know now from the Brazel judgment that that worker will be entitled to 5.6 weeks of pay for holidays over the course of the year if they're working on an ongoing contract. So not on a fixed term contract that ends partway through the year. So if we move on to the next slide then, please, Tamar. The calculations that are going to be most relevant in an HE setting are calculations that apply to staff who have normal working hours and pay that doesn't vary. So this could be anyone who is working during term time, but paid on an annual basis, so paid a salary over the course of the year, and they would work fixed hours during their working time, but their pay would be annualized so that they're getting a consistent wage throughout the year during periods of vacation time when they're not required to work. And so providing that that calculation has their pay for the weeks that they're working, plus a minimum of 5.6 weeks statutory holiday, and then is averaged out over the course of the year. They can take their statutory holiday when the university isn't in session, and when they're not working, they're receiving the same rate of pay as they do during term time. So that will apply to your annualised hours staff. And the other method of calculation and group of staff that the Brazel judgment particularly affects are casual workers, or workers whose pay varies depending on the amount of work that's done or the hours that they're working. So they don't have a fixed work pattern, and their pay and their hours change from week to week depending on demand. So for universities, that would be your sort of hourly paid lecturers whose hours are determined by demand for a particular subject, and whose hours could fluctuate from term to term, from week to week, or from year to year. And to calculate their pay for a week, you would be looking at averaging back over the last 52 weeks to see what they've earned over the course of the year. And the calculation would remove any unworked weeks from that average, so that their rate of pay doesn't dip down to reflect periods when they're not working. And because that would mean that you might not have a full 52 weeks of working hours, you can look back over a further reference period going back to a maximum of 104 weeks to calculate that average pay. And for people who have just started with you and haven't been with you for a full year, you would do an average based on their worked weeks with you during that first year to get their week's pay. And because this calculation has to happen at the time a member of staff is taking their holiday, you'd need to redo this calculation at various points in the year, unless you determine that holiday will be taken at specific times, in which case you can run those calculations at designated points throughout the year, rather than doing it on demand of staff wanting to take holiday. And you'd need to ensure that over the course of the whole year, that staff who have this part-year work pattern or work on a casual basis have at least their statutory 5.6 weeks holiday. So if we move on to the next slide, please, Tamar. And if we look at a practical example, so if we look at this case study, we've got Miss Smith, who is an hourly paid lecturer. Her working hours vary subject to demand. She does not work during the holiday periods of the university. She's paid £50 an hour, and this includes rolled up holiday pay at a rate of 12.07%. And as Michael said, that was the rate that used to be promoted by ACAS as being a fair way of determining a proportion of holiday for part-year or part-time workers. And the last academic year, Miss Smith worked for 2 terms out of 3, working 10 hours per week for 20 weeks over the academic year. And this is the first year that she's worked for the university. So if you move on to the next slide, we'll look at what her entitlements are and how we calculate them. So because Mrs. Smith is working an unset pattern of hours, she's got no normal working hours, so we have to work out what her week's pay is, looking at that 52-week average. And so we would look back over the course of her employment. She hasn't worked for a full year, so we can only average on the weeks that she's worked during the year so far to calculate what 5.6 weeks holiday the value of that holiday would be. And because she is being paid rolled up holiday pay, we would need to be able to strip out from that rolled up element what her actual hourly rate is compared to the 12.07 enhancement that's been added for pay. And so if we move on to the next slide, we can see how, if you compare the percentage method, which has rolled up holiday pay, that for the 200 hours that Miss Smith worked, the element of her hourly rate for or the rolled up holiday pay was £6.04. And so if you look at that example here, £1,208 of holiday pay be paid to her on a rolled up basis. But if you look at how the working time regulations calculate that pay, her hourly rate, if you strip out rolled up holiday pay, is £43.96, times that by the 200 hours that she's worked, the 20 worked weeks that she's worked them for, and her weekly pay is £439.60. And if you times that by 5.6, which would be her statutory entitlement to holiday, her holiday pay using the working time formula is £2,461.76. So you can see there that the percentage method that was looking at a proportion of holiday prorated to the equivalent of a full-time member of staff, and the working time regulations method, which determines you've got to have 5.6 weeks holiday and paid at the week's pay, creates quite a high differential in terms of the amount that the employee is entitled to. So the difference here is £1,256.76. So if you can imagine, if you did this calculation looking back over the last 2 years, there might be a liability there that you would need to pay and back pay, should Ms. Smith bring a claim. And going forward, you'd need to adjust the method in which you calculate pay to ensure that that liability isn't reoccurring in the future. So if we move on to the next slide, please, thank you. And if we look at a further example, and this one we're going to do as a poll, so there's an opportunity for you to vote as to which of the calculations that you think would apply here. But Mr. Peters is a term time only lecturer engaged under a fixed term contract, which is renewed annually, and he takes his holiday outside of university term time. How should we pay his holiday pay to comply with the working time regs? So you've got the opportunity here to pay rolled up holiday pay, which is something that the sector routinely uses for staff who work variable hours. You can pay him in lieu of his accrued holiday at the end of the fixed term contract, or you can require him to take holiday with pay at specific times during the course of his contract. So if you'd like to vote. Okay, so the majority of those who responded to the poll have said, 64% have said, take pay and holiday at designated times across the year. And this is the sensible approach, because in those circumstances, one, you're not looking at putting back-to-back fixed-term contracts in place where you're paying holiday during a period of cessation of work, where you're looking at potentially creating a continuity of employment there. So it's sensible to make sure that holiday is paid during the course of the year. If you continue with rolled up holiday pay, there's always a risk there because that's not strictly compliant with the working time regulations. And so there should be consideration of a move away from that. So yes, paying at designating times during the course of the year outside of when he's teaching is a sensible way of managing holiday pay liability and making sure that he's taking holiday and rest as intended by the working time regulations. So if we move on to the next slide, please, Tamer. And we look at a further example. So if we look at Mrs. Jones, who works as an exam invigilator, she's been on a contract with the school for, with the university for a number of years. She's been on a register of casual staff. So she's got ongoing contract in place, but she only works on average 8 weeks per year doing exam invigilation. And she's paid £20 per hour, and her holiday pay is calculated at a rate of 12.07. So if we look at this example in a bit more detail and move on to the next slide. Again, Mrs. Jones has no normal working hours. So the way in which you would look at calculating her week's pay for the purposes of holiday is using a 52-week average. And she would be entitled to 5.6 weeks holiday per year. And on the basis that she's only working for such a small part of the year, just doing 8 weeks, you see that that would create quite a disproportionately high amount of holiday to the amount of work that she's doing, and could create something of a windfall to her, and would be seen as quite disproportionate to other members of staff who are working for significantly more weeks of the year to gain the same amount of holiday entitlement. So in these circumstances, it might be appropriate to consider whether the contractual arrangement that she's on, this ongoing casual contract, is the right type of contract for the nature and the amount of work that she's doing every year, and whether there is a way of avoiding this disproportionate amount of holiday. So if we move on to the next slide, please, Tamar, we'll have a look at some of the different kinds of contracts that you could think about putting into place. So for casual staff with variable hours, if you have staff who are working sort of week in, week out, doing different hours, but consistently through much of the year, then an ongoing casual contract may be the right and appropriate contract for that kind of work. The benefit is that they're ready and available to take on work as and when you need them. You don't need to repeat any onboarding checks. You don't have to take them on and off of your payroll. But the flip side of that is that they are entitled to their 5.6 weeks, and it will be based at their usual rate of pay, using the 52-week calculation to get their average rate of pay. So if you're using staff frequently, that casual contract model on an ongoing basis works. If we move on to the next slide and have a look at some of the different options that are available. For staff like the last case study example we just looked at for Mrs. Jones, who work only for short periods for specific requirements throughout the course of the year, so exam invigilation or coming in for a specific event, it may be appropriate to think about using fixed term contracts because you are able to apportion holiday in first and last year of employment. So if you're using a fixed term contract for an 8-week engagement, you will be able to prorate that holiday entitlement down based on the amount of the length of that contract. And you'll be able to pay that at the end of the contract when the employment or engagement comes to an end. One drawback of fixed term contracts is that if you use them on a repeated basis, because there are frequent engagements and you're taking them on and off of the books, there's additional onboarding of staff to do. And there is the risk that the arrangement does start to create continuity of employment because there are fixed or clear secessions around around the holiday period where they're not working and then they're engaged for another term and then off for the holidays. In those circumstances, you can see that there would be a case potentially to argue that those fixed terms over customary practice become an ongoing relationship where 5.6 weeks holiday would be entitled to and statutory rights in terms of other matters like unfair dismissal start to accrue. So fixed term contracts work for those discrete short-term engagements where you can then manage the holiday pay liability, and it avoids a situation where you are creating that disproportionately high amount of holiday to the amount of time worked. If we move on to the next slide, please. Another contractual arrangement that you could consider is the assignment model. So having an overarching contract with an individual whereby they are offered assignments, and during those periods of assignment, they're your employee and they accrue holiday and other employment rights. And when they're not working under an assignment, there is no ongoing employment relationship. The overarching contract sits in place, but needs to be carefully crafted to ensure that that in itself doesn't create an employment or worker arrangement. And in those circumstances where each assignment is seen as its own individual short period of employment, you could pay accrued holiday at the end of each assignment based on the length of that assignment, rather than the full 5.6 weeks if there had been an ongoing contract of employment that lasts on a permanent basis. So this option is sort of a halfway house between the two previous options that I talked about, and can work where you might have a bank of lecturers who are coming in to cover or to take on work, and you want to have them available and have their be able to issue them with an assignment, but the frequency of the demand for them isn't there in the same way as would fit perhaps better with a casual contract. This is a less tested area, and the more that each assignment starts to look like employment and an ongoing relationship in between, an ongoing relationship in between each of those assignments would start to undermine that pocket of employment approach where you're looking at paying holiday at the end of each of those assignments. So with consideration of which contract fits which type of work best, it's a balance really of financial saving on the 5.6 weeks holiday if you can reduce that requirement, against the inconvenience really of onboarding staff and taking them on and off of your payroll by assignment or by fixed term contract. So if we move on to the next slide, please. And if we look at some of the questions that we've been asked since the Brazel judgment. So a number of employers have said, can we prorate holiday entitlement for part-time staff? So the answer here is no, in the sense that all staff working on an ongoing basis are entitled to 5.6 calendar weeks holiday, statutory holiday. But a part-time member of staff who works, say, 2 days a week, their week's holiday is equivalent to 2 days, whereas a full-time member of staff is equivalent to 5 days. So there is the natural prorating based on their FTE that would still be there, but they're still entitled to 5.6 weeks overall. And their pay obviously reflects the fact that they work fewer hours, and so the pay that they receive for their holiday is that reduced level as well compared to a full-time colleague. If we move on to the next slide, please, Tamar. So are permanently retained staff who work for multiple employers entitled to 5.6 weeks holiday from each employer? The answer to this is yes, and that seems illogical in a way. However, if you look at the practical arrangements, if someone's working for 2 different employers and they work 2 days for one, 3 days for the other, when they come to take their holiday, they get 2 days, the equivalent of 2 days pay holiday from one, 3 days from the other. So when they're having their holiday, what they're receiving is the same sort of income that they were previously having. They're not getting a bumper amount of holiday, but yes, each employer would be required to provide them with their 5.6 weeks using the statutory calculations to calculate what a week's pay is based on the hours they work or the variable hours. If we move on to the next slide, please, Tamar. So must we also pay unreduced contractual holiday? The answer to this is no. So if you have appropriate clauses within your contracts that allow you to prorate holiday for part-time and part-year workers, you can apply those clauses, providing that the holiday that a part-time or part-year worker receives doesn't fall below 5.6 weeks in total. So that you're always meeting the statutory minimum, but you can be fairly apportion holiday, enhanced contractual holiday, so that there isn't that disparity between staff who work all year round receiving proportionately less than their part-year colleagues in relation to the contractual holiday they're entitled to. If we move on to the next slide, please. And I'll hand you back over to Michael to talk about some of the strategic considerations following the judgment in Brazel.
Thanks very much, Joe. Had a few problems with my stop video button there, but I'm back. And going to look at now some strategic considerations. So what practical steps have we been thinking about that you might want to take following the Brazel judgment? And the overall process that we've been recommending is that first you establish whether there has been a historic underpayment. Second, you establish if any of the contracts of employment need updating or amending. Third, you decide how you will pay holiday pay going forwards. So how you're going to fix any problem which you've identified. And fourth, decide on an approach to back pay if there is a liability. And then fifth, communicate with staff, which is obviously a key point. We're going to look at each of those in a little bit more detail as we go through. So first, looking at whether there's been an underpayment. Seem to have moved on to a different slide. Okay, yes, that's the slide I was after. Thank you. That's perfect. Looking at whether there's been an underpayment. And remember that we're looking at part year workers here. So casual workers who don't work every week of the year, turn time only workers if you have them. If you've been applying a 12.07% multiplier and paying them sort of on an hourly basis, then there is very likely to be an underpayment. I know that some institutions pay a higher percentage, and of course the higher percentage will reduce the overall liabilities potentially, and may even extinguish them altogether. Once you've looked at the rate of pay and how it's been calculated, the next thing is to have a look at the contracts and to make sure that those marry up in the first instance with the way that people have actually been paid, and whether the contracts are going to need amending, something which Joe's already talked about a bit. So the contracts should provide for 5.6 weeks holiday. You need to also make sure that there's no minimum wage issues. So that would be for the hours worked plus 5.6 weeks holiday. Moving on to the next slide. Carrying on with the underpayment points. Once you've looked at your contracts, and they might say, for example, you've got 5.6 weeks, or it might say that you're entitled to the statutory minimum. On the first instance, that looks like it'll be fine. It may not require amending. But what we've been recommending is looking underneath that to see how the payroll system is actually calculating holiday in those situations and how the salary has been set in the first place. We have come across circumstances where the contract might say 5.6 weeks, but actually the payroll system or other calculations are basing on a 12.07 multiplier. So you need to be sure that you can rely on what's said in the contract, because of course, if there was any dispute about these things in the future, payroll data and other underlying calculation data may be disclosable. Once you've carried out the review, you'll be in a much better position, of course, to determine how you're going to manage staff relations going forward. And we'll look at that in a bit more detail in due course. Turning on to the next slide. Next, looking at correcting holiday pay going forward. Well, the first thing is, and something that Joe's talked about in a bit of detail, is amending the contracts if required. So the contracts need to say 5.6 weeks or need to reflect that entitlement. Amending the contract, of course, it needs to follow some sort of a process. There may be side letters you send out, there may be amended contracts that require signing and returning, but that's something which needs to be thought about in the overall strategy. When you're correcting the holiday pay, it's likely that there's going to be an increase in costs because part-year workers, the overall effect of the Brazel judgment is that there is an element of a windfall, I suppose you might say, or increase in the value of holiday for those individuals. So managing costs is going to be part and parcel of the strategy, and that might be using discrete contracts if appropriate, and that generally means using more fixed-term contracts or contracts that terminate at the end of a particular activity. As Joe said, you need to look at the life cycle of those contracts to see if that is going to be a administratively proportionate thing to do in terms of the onboarding costs and the administration costs in generally speaking. Will you be seeking to reduce term time only or other types of part-year contracts moving forward? That may well be something that you might seek to have fewer people employed, but those people working more regularly. And will there be an impact potentially consequentially on flexible working requests as a result? I know that some flexible working requests include a request to work term time only, and the question about whether that will be viable moving forward. Incorporating additional holiday pay, there's a question about when's the right time to do that and how to do that, and you might consider as building that into an annual pay review. I think the key thing there is to be absolutely transparent if you do that, to ensure that communication is clear. And of course, there may unfortunately be a requirement to claw back increased costs from elsewhere by way of restructuring potentially, or fewer, more heavily used casual staff. But that depends overall on what the liabilities are seen to be and how much slack there is in the system. Moving on to the next slide. Assessing the arrears of back pay. If there is a liability for back pay, then there is a 2-year rolling backstop for holiday pay deduction claims, wages claims. So that's your basic position in respect of liability. Could it be less? Well, there is the ruling in the Bear Scotland case, which talked about if there's been a gap of greater than 3 months between holiday payments, then that might break the chain of deductions, and that might be an avenue for reducing the liability, the arrears, to a period shorter than the 2 years. However, that rule has been criticised quite heavily in recent judgments, particularly one arising in Northern Ireland and the Pimlico Plumbers case at the Court of Appeal here. So the deductions rule and the time limit rule there, that may well be something which, whilst you might rely on initially, might get tested in the higher courts and might not actually hold up. Moving on to the next slide. So what's the best commercial approach to back pay if there is a liability? Well, you'll see here we've got a series of ORs on the slide, varying from carrying out individual calculations for everyone who's affected, all the way down to not offering or volunteering anything. And I think where you sit on that scale depends probably on having undertaken that review, which I've talked about earlier, and understanding historical liabilities in the context of your institution, and being able to make a sort of risk-assessed judgment about how best to go forward. If you're fixing the problem for the future, then of course there will be a 3-month time limit for people to bring claims in respect of previous shortfalls in holiday payment. And I guess you might take a view about the likelihood of claims arising within that period once the issue's been fixed. You'll I guess also need to think about the potential approach taken by unions and by individual members of the workforce if they become aware of the case and its implications for them. And I think overall it's all about the assessment of risk in the context of your own liabilities. Moving to the next slide. So when will you pay holiday pay going forward? Well, it's likely to be more complicated, but for annualized hours staff, you'll pay on a regular monthly basis, I guess, and that's fairly straightforward. For staff whose pay varies or have no normal working hours, you may want to decide on a payment schedule. So, for example, designating times when holiday might be paid in the contract of employment. Some case law around holiday being taken at the time, being paid at the time it's taken. And whilst obviously that can't be ignored, I think you need to balance that out with the practicalities of potentially having to carry out average pay calculations for people whose pay varies each time they take leave, and how administratively realistic that is. I guess part of it will be checking whether your payroll systems have the ability to calculate average weekly pay over 52 weeks in the event of someone taking leave. If those people taking leave are dotted all over the place, it's got to be a calculation carried out many times. If there are designated times when that leave is paid for and people are asked to be on leave, if that's practical, that might be more administratively straightforward. Going on to the next slide. What must we say in the contracts? Well, essentially, they need to reflect that all staff are entitled to 5.6 weeks annual leave, and we need to move away from any reference to prorating or percentages. Ideally, of course, as it says on the slide, you confirm the position on public holidays, make it clear that holiday pay is included in salary for salaried staff. And as I've just been talking about, it is possible it would be administratively realistic to confirm when holiday is going to be taken for those with irregular hours. Moving on to the next slide. How will you communicate with staff? And I think this is a key issue, and it's something which is best determined once the problem is well understood through the review that we've talked about. And it's obviously something which will benefit from very clear messaging, an element of transparency, and an element of consistency. I think that you definitely need to fix the position for the future, because obviously otherwise you're going to be left with an ongoing liability, potentially, which hasn't been remedied, and there is that 2-year rolling back pay liability. Once you've fixed it definitively, you can move forward from that, and that liability is then set and will either be extinguished through time, or you'll be able to deal with it. Opinions are obviously going to vary about the extent to which you volunteer back payments to members of staff, and that's going to be an institution-based, risk-assessed decision. I think the good news is that in terms of communicating with staff and fixing the way forward, there is quite a clear message which can be given, because of course you can say that we have complied with what was ACAS and government guidance, and it's only now that there's a change in the law that we're having to change. We're changing that to ensure compliance moving forward. There's no sort of question of unscrupulous behaviour or anything like this in the past. It is actually a change in the law, which, if messaged in the relatively near future, I think can give some coherence to the university's position. Moving on to the next slide, which is the final one, and that's just a reminder of those steps I talked about at the start: establishing the underpayment, updating holiday pay calculations, deciding on how that holiday will be paid going forward, deciding on an approach to back pay, and then the all-important communication with staff. Okay, so that's the end of our slides for today, and we'll now move into dealing with questions. So both Joe and I think Jess will be involved in this. Jess, have you been able to identify any themes in the questions which have been coming up?
Hi, everybody. Yes, I think one thing that I've said on the question box, it'd be good to talk through because there's a lot to consider, is in scenarios where payroll systems are struggling to cope with this new way of calculating holiday pay. We've had several questions saying, is it possible to choose a percentage multiplier and fix it at a number higher than 12.07% for everybody? And what are the risks of proceeding in that way?
Well, the you could potentially fix a multiplier if all of your part-year workers work the same amount of number of weeks in the year. The problem for that is if you have different categories of workers working different numbers of weeks, or if the weeks vary from year to year, the multiplier won't be good for all of them. Of course, there is a practical point that you might think, well, if the multiplier is generous, then people might just say, well, it may not be perfect, but it's a good deal. I'll take that, and I'm not too worried about it. And you may not face any realization of any historic liabilities, and the risks moving forward may be manageable. But in terms of legal compliance, that will only work, as I say, if you've got categories of workers who all work the same number of weeks a year.
Yeah, thank you, Michael. So I suppose what I would add to that is if this is an approach you're considering, then what I would suggest you do is go and look at the person that you've got who is permanently retained but under the fewest working weeks per year and work out what the percentage would be for that person. And I think that will give you a good indicator as to whether it's the commercially viable approach or not. So the other kind of theme that's been coming up kind of again and again is whether we need to proactively contact our staff who've left, who might have been affected by the judgment if they were still employed by the university.
Do you want me to pick this one up, Michael?
Sure, we can both chip in.
So in terms of proactive contact with staff who've left, if they themselves aren't pursuing a claim or they're not contacting you following the judgment, then there's no obligation on you to follow up. It may be that you feel that it's appropriate if you are paying back pay to other members of staff. You would need to think about when they left and whether they would still have a claim, whether they were within relevant time limits for bringing that claim. If they left more than 3 months ago, for example, and they have started a CAS early conciliation in relation to a unlawful deductions claim, then they would be out of time to pursue it. So it's a commercial decision really as to whether you would pursue it.
Fab, thank you. Have you got anything to add to that one, Michael, or shall I throw another question out there?
Yeah, I mean, I suppose on a practical level, one might say, well, if people have left, I'm going to concentrate on the people that are here rather than the people who have left. But I guess it all needs to go into the overall strategic mix.
Absolutely. Thank you. We've had a question in about national minimum wage considerations. So where we're looking back over the last 52 worked weeks, and that might take us below the current national minimum wage. I know this is something we've been talking about recently internally. I'm happy to just kind of update on our latest thinking on this, because it's there is a scenario where if you look at the last 52 worked weeks going back up to 104 weeks, your calculation is going to take you below the current national minimum wage. And on the basis, there's no kind of clear authority one way or the other, but if you go back to basics of the principle of the purpose of holiday, and the fact that you don't want to disincentivize somebody from taking holiday. I think what our advice is to make sure that they're receiving at least national minimum wage when they are those lower paid workers, even if your technical calculation going back to the last 52 worked weeks comes out at a lower level. Because if you don't do that, then somebody's going to be in a position where they will earn less money by going on holiday than they would have done if they were just going to sacrifice the holiday and work as normal. And we don't think that's in the spirit of what all the holiday pay law it sets out to achieve. Just looking at how we're doing for time. Can we just revisit, I think, in terms of terminology, there seems to be lots of questions around people who are engaged on fixed term contracts and sometimes successive fixed term contracts. So I think we need to just clarify for the benefit of some of the attendees, when we're talking about people who are affected by the judgment as being retained on a permanent basis, to what extent that relates to fixed term employees.
Sorry, I was struggling to unmute.
Okay. Are you going to cover that one, Jo?
I'll start off
Okay.
and please do add anything
Yeah.
in. I suppose you're looking at whether they've got continuity of service. So if you have a successive use of fixed term contracts, one to the next, and they have continuity, they're going to be a permanent member of staff, and the 5.6 weeks holiday is going to apply. If it's a genuine short-term fixed term contract, I think one of the questions mentions of a 6-month contract, then the proportionate holiday entitlement for that contract is going to be half of the annual entitlement to 5.6 weeks. But then if they entered into another contract straight on the back of that, you're getting in a position where you're starting to create that continuity. And if you keep doing that, that member of staff is going to be a continuous member of staff on a permanent contractual arrangement with you.
Thanks, Jo. We've had another question about, and this is a slightly different type of question, about what we think might happen in future. Do we think that this legislation could be amended to address the balance, if you like?
I think at some point there may be appetite to revisit the legislation, because various decisions have meant that it's quite difficult to interpret, and some of it commentators would say doesn't make sense as much as it should in a modern workplace. But whether there's appetite at the moment to do that, it's certainly not on the legislative roadmap at the moment to do that. So at some point it may change, but I don't think we've got any timeline for that happening.